Kensington Palace, Saturday, March 14th, 2026. While the rest of the world is scrolling through the morning's headlines, still processing the consequences of what happened in Sydney the previous day, still absorbing the implications of the steel strike, still trying to calculate the full dimensions of the Sussex brand's commercial collapse, a single manila envelope is placed on a mahogany desk. It does not arrive through the standard press office. It does not pass through the normal channels of palace communication, the ones with timestamps and distribution logs and the signatures of communication staff who can be asked later to account for what they sent and to whom. This envelope travels by a different route entirely. Insiders with knowledge of the delivery have a name for the mechanism. They call it the invisible hand. The person receiving the envelope is Tom Bower. If you follow the landscape of British investigative journalism with any seriousness, the name requires no introduction. Bower has spent decades building a reputation as the author who goes where other authors will not, who pursues the records that public figures work hardest to keep sealed, who has a specific and long documented talent for finding the documents that were supposed to have disappeared. He has been working on this particular story, following this specific thread, chasing this precise set of inconsistencies for years. He has been close before. He has had pieces of the puzzle, outlines of the picture, suggestions of the shape of what the full evidence would reveal. What he has not had until this afternoon is the document that assembles those pieces into something that cannot be dismissed, reframed, or managed through the mechanisms of a well-funded PR operation. Inside the envelope is a 42-page dossier. It is bound by a single stainless steel clip. On its cover, stamped in the specific red ink that carries within the British governmental system the weight of centuries of institutional authority, are two words: Privy Purse Confidential. The document is a forensic audit, not of finances, not of the commercial arrangements that have been occupying so much of the palace's attention in recent days, but of something more fundamental, of a public identity, of the documented record of a life as it was presented to official institutions, cross-referenced against the record of that same life as it was presented to other official institutions, of the gap between those two records, and of what that gap means legally, constitutionally, and institutionally for the monarchy, whose official records contain both versions of the story. But here is what makes the dossier's arrival on Bower's desk something more than the conclusion of a long investigative process. Here is the detail that transforms this from an ordinary, if explosive, journalistic development into something with the specific quality of strategic precision. Tom Bower did not obtain this dossier through the ordinary mechanisms of investigative journalism. He did not have a source who copied documents and passed them through back channels. He did not file Freedom of Information requests that accidentally returned more than they should have. He did not intercept a communication or gain unauthorized access to a protected system. The dossier reached him because someone working within the highest levels of the British royal household made a series of specific decisions about which doors to leave unlocked, and which corridors to leave unguarded, and which archival search requests to process, with an efficiency that went slightly beyond what the situation strictly required. Multiple sources within the royal household, speaking with the careful circumspection of people who understand the institutional weight of what they are describing, have converged on a single characterization of what happened. Prince William, the Prince of Wales, the man who is currently functioning as the operational sovereign of the British Monarchy, while his father remains its constitutional head, has moved from a position of passive silence to active tactical facilitation. He does not leak. The distinction is important, and the people who know him well are insistent about it. He does not brief tabloids. He does not whisper to journalists over private lunches. What he does, what he has apparently decided, at some point in the weeks preceding this Saturday afternoon, that the situation now requires is facilitate. He leaves vault doors unlocked for the investigators he trusts. He ensures that the right requests are processed by the right offices with the right level of administrative cooperation. He provides, in the language of one senior aide who described the process with evident admiration for its precision, a logistical map through territory that would otherwise be impassable. Williams reported words to his inner circle, reconstructed through the accounts of those present at the relevant conversations, have the quality of a man who has reached a conclusion through a long process of reasoning and has arrived at a place of complete clarity. The crown, he said, is built on the integrity of the record. If the record is a lie, the crown must correct it. When asked about his brother about what the correction of the record would cost, Harry personally, his response was equally unambiguous. Harry chose his path, he said. I am choosing the monarchy. Those two sentences, spoken by a future king in the context of authorizing the facilitation of a 42-page dossier, describe a decision of extraordinary institutional consequence delivered with the quiet certainty of someone who has been preparing to make it for a long time. The 42 pages inside that stainless steel clip document are not the product of a single investigation or a single source. They represent the assembly, through a process that apparently took years and required access at multiple institutional levels, of a body of evidence that individually consists of fragments and inconsistencies and questions, but collectively constitutes something that investigators working at the level of Tom Bower describe with a specific word: irrefutable. Not explosive. Explosive is the language of tabloids, and it implies that the conclusion could still be argued with. Irrefutable is the language of document forensics, and it implies that the conclusion has been reached by a process whose methodology is available for examination and whose findings cannot be dislodged by alternative interpretation. The dossier is organized around what Bower's team has been calling the authority staircase, a three-tiered hierarchy of documentation designed to address, at each level, the most likely counter-argument to the findings of the level below it. The first tier establishes the inconsistency. The second tier establishes its institutional significance. The third tier establishes its legal consequences. By the time a reader has ascended all three levels, they are not in the position of someone who has been presented with allegations. They are in the position of someone who has been presented with a structured legal and institutional case built on primary documents from multiple jurisdictions that points in a single direction with a consistency that rules out coincidence as an explanation. At the base of the staircase are the professional records. These are documents that exist because the systems that produced them had no reason to lie and no awareness that they would one day be assembled alongside other documents for the purpose of comparison. Federal-level insurance filings with the Screen Actors Guild and the American Federation of Television and Radio Artists from 2005 actuarial documents in which age determines premiums and payouts and liability, in which the financial consequences of inaccuracy run in both directions, and in which the people completing them understand that the information they provide is subject to verification by systems that do not accept publicity bios as substitutes for certified records. These documents, according to sources close to Bower's investigation, record a birth year that does not match the birth year that has been publicly associated with the Duchess of Sussex throughout her royal life. Money, as Bower has observed in characterizing the significance of this finding, follows the truth. And in 2005, the money was following a different timeline. The second tier of the staircase ascends into the institutional. This is where the invisible hand of Kensington Palace becomes not merely plausible, but, in the reading of those who have studied the document's provenance, essentially undeniable. Under normal circumstances, the historical records that form this tier of the dossier are subject to strict privacy protocols, the kind of protections that exist specifically to prevent the personal documentation of private individuals from being assembled for comparative analysis without their knowledge or consent. But the Prince of Wales, in his capacity as a senior member of the Privy Council and the future head of the institution whose official records are at the center of this investigation, possesses authorities that do not belong to ordinary investigators. Among those authorities is what is known in the relevant administrative circles as a special search, a mechanism that allows the direct side-by-side comparison of documents held in different institutional archives, triggered when there is a compelling institutional reason to verify the consistency of records that have been submitted to Crown institutions. When those documents were assembled and compared the professional filings from Los Angeles against the certified materials submitted to the palace for the royal wedding preparations, they did not match. The specific nature of the mismatch, as described by sources with direct knowledge of the comparative analysis, is not a minor administrative discrepancy of the kind that records sometimes contain through innocent clerical error. It is a structural inconsistency, a gap between two versions of the same biographical fact that is too large, too consistent across multiple document types, and too precisely correlated with the known mechanics of a specific industry practice to be explained by anything other than a deliberate act of identity management. The dossier does not use the word fabrication. It uses the language of documentary forensics, material misrepresentation. The distinction matters legally, and the people who compiled the 42 pages are people who understand why. To understand the full architecture of the inconsistency the dossier has assembled, you have to follow the professional timeline from its beginning. Not the beginning of the public story, the actress from Los Angeles who became a television star in Toronto and then a duchess in Windsor, but the beginning of the documented record, the paper trail that predates the public narrative and that has been accumulating in archives and filing systems and insurance databases throughout a career that began long before most of the world was paying attention. A 1,997 editorial profile in a major American publication describes its subject with a biographical precision that journalism of that era routinely applied age confirmed through standard editorial verification processes. The age listed does not align with the birth year that has been publicly associated with the Duchess of Sussex. The discrepancy is not marginal. A former staff member at the publication, speaking to members of Bauer's research team, was direct about the verification procedures applied at the time. They did not make mistakes about age, the staff member said. They checked identification documents for release forms. The number they printed was the number that had been verified. That number is preserved in print, in an archive that predates the digital era and its associated editorial flexibility, in a form that cannot be quietly corrected through the back-end systems of a platform that accepts professional corrections without formal challenge. The academic records represent a second tier of the professional timeline's documented inconsistency. The university file was placed under a high-security seal shortly after the royal engagement announcement, a decision that attracted attention among academic administrators familiar with the standard procedures governing graduate records, which are not ordinarily subject to the kind of protective classification applied to state secrets. The enrollment dates contained in that file, according to sources who had access to it before the seal was applied, and the age of the graduating cohort with whom the subject studied, do not align with a biography anchored to the birth year that has been publicly established. The records remain sealed. But the invisible hand that facilitated the dossier's assembly has reportedly obtained materials that speak to what those records contain. The 2005 SAG-AFTRA filing is perhaps the most institutionally significant element of the professional timeline because it represents the point at which the inconsistency enters a federal document of the kind whose accuracy is enforced not by social convention or professional courtesy, but by the actuarial mechanisms of an insurance system that has direct financial consequences for errors in either direction. These are not publicity biographies. They are not industry profiles designed to present a subject in the most commercially favorable light. They are federal-level insurance documents, in which the number recorded determines premiums paid and benefits received, and in which providing an inaccurate number is not a branding decision, but a financial act with legal consequences. The number in those documents, according to the dossier, does not match the number on the Royal Marriage Registry signed on May 19, 2018. Bauer's name for the process by which a public identity is rebuilt around a revised biographical anchor is the rejuvenation mechanism, and his forensic reconstruction of how it operates in the specific case documented in the dossier is one of the most clinically precise sections of the 42 pages. He is not He is at pains to establish describing something unique or unprecedented in the context of the entertainment industry. The practice of maintaining a stage age, a professional biography that presents a subject as younger than their documented birth records would indicate, is common, understood, and in many contexts tolerated as a necessary accommodation to the commercial realities of an industry that applies dramatically different valuations to talent at different ages. What Bauer is documenting is not the practice itself. It is the specific trajectory of that practice from its origin as a commercial survival tool to its arrival, through a series of incremental and individually defensible steps at a point where it intersects with the constitutional requirements of the British monarchy. The first stage of the mechanism, as reconstructed in the dossier, is digital sanitization. Before the global attention generated by a major television series, there were traces of an earlier professional life, local reviews, industry platform profiles, early biographical materials on niche entertainment databases that reflected a different timeline than the one that would later become established. Bauer's investigation suggests a systematic review of these materials took place in the period between 2010 and 2012, during which older digital references were quietly removed and archive entries were purged of content that would have created friction with the revised narrative. If the data does not exist, the argument runs, the past does not exist. The logic is brutal, and in the context of a pre-social media entertainment career, it was largely effective. The second stage exploits a specific vulnerability in the infrastructure of professional biography management. Major entertainment industry platforms that function as the canonical reference for professional credentials maintain subscription-based services through which talent agents and managers can update client biographies. The system is designed to accommodate genuine professional corrections, name changes, credits added after initial publication, biographical details updated as careers evolve. It accepts updates as professional corrections as long as no formal legal challenge is mounted. By applying this mechanism to the birth year entry, the revised timeline was given a form of official-looking legitimacy that casual verification processes, the kind applied by journalists, casting directors, and brand managers, would accept without question. The third stage is psychological, and it is in some ways the most sophisticated element of the mechanism because it operates not through documents, but through narrative. Bauer identifies what he calls false memory, anchoring the practice of repeatedly telling emotionally resonant stories from a specific period of life that implicitly anchor the listener's sense of the subject's age at that time. A story about writing letters to a soap company manufacturer as a child activist, told with a specific emotional detail that makes it feel authentic, and with the biographical context of a precocious 11-year-old, creates in the listener's mind a timeline that they have not verified, but that they have experienced emotionally in a way that makes it feel more reliable than a document. The psychological literature on constructed memory is extensive, and Bauer draws on it explicitly. Narratives that are experienced emotionally are retained and transmitted differently than information that is simply recorded. The fourth and final stage of the mechanism is contractual binding. By the time the revised timeline had been established across professional platforms, entertainment industry databases, and the informal biographical currency of Hollywood publicity, it had been incorporated into formal contracts with major talent agencies. In the commercial logic of the entertainment industry, the age differential between a woman in her early 30s and a woman approaching her early 40s represents a significant difference in commercial valuation for leading roles in beauty endorsements. That differential, once it has been incorporated into signed contracts that carry financial penalties for material misrepresentation, transforms what began as a professional biography adjustment into a legally binding representation that a multi-million-dollar PR infrastructure has an active interest in defending. The transition of deceit, as the dossier describes it, is complete when the stage age is no longer a personal choice but a contractual obligation. The legal pivot point of the entire dossier, the moment at which everything that preceded it transforms from a professional inconsistency into a constitutional question, is May 19, 2018, St. George's Chapel, Windsor Castle. The signing of the Royal Marriage Registry. In British law, the validity of a marriage is predicated on the accuracy of the identity provided at the time of the ceremony. This is not a technicality or a procedural formality. It is a foundational requirement of the Marriage Act of 1949, which establishes that the legal instrument of a marriage, the registry that creates the public record of a union under British law, derives its validity from the integrity of the information it contains. A party who knowingly provides materially false information regarding their identity at the time of signing that registry does not simply commit a social impropriety. They commit an act with specific and documented legal consequences under the statute. The marriage, under the terms of the act, enters the territory of being voidable, not automatically void, but subject to challenge on grounds of material misrepresentation if the falsification of identity can be established to the required evidentiary standard. Legal analysts who have been briefed on the dossier's findings, speaking in the careful, conditional language of lawyers who understand the difference between a strong legal argument and a concluded legal fact, have been characterizing the questions the document raises as genuinely significant. Not tabloid significant, not the significance of a story that generates attention and then fades as the news cycle moves on. Constitutionally significant. The question of whether a marriage entered into using identity documents that contain material inconsistencies with other official records of the same identity remains fully binding under English law is not a question with an obvious answer, and it is not a question that the palace's legal team can be expected to leave unexamined given the nature of the documents they have now received. The material misrepresentation clause, the specific legal mechanism identified in the dossier as the instrument through which the documented inconsistency becomes a constitutional matter rather than a biographical curiosity, operates at precisely the intersection where the entertainment industry's tolerance for stage ages meets the British monarchy's requirement for the integrity of its official records. What was legally unremarkable in a casting office in Toronto became legally material the moment a signature was applied to a government document in a chapel in Windsor. The dossier does not argue that the marriage is void. It establishes the documented basis on which it could be challenged. The distinction is significant, and the people who compiled the 42 pages are people who understand the difference between establishing a fact and reaching a conclusion. The people who have watched Harry's public interviews carefully over the years, who have paid attention not to what he says, but to what his body does while Meghan is speaking about her formative years, her early activism, the biographical context that establishes the timeline, her public identity is anchored in, describe a consistent and striking pattern. When the subject turns to those early years, his posture changes, his gaze drops. He does not look at the camera, does not look at his wife, does not perform the supportive attentiveness that characterizes his demeanor in other sections of those same interviews. He looks at the floor. It is a small thing, and in isolation, it would be meaningless. In the context of what the dossier describes, it is the physical manifestation of a man who knows something and has been carrying the knowledge of it for years. Bauer's assessment, laid out with the measured precision of an investigator who is careful not to claim more than his evidence supports, is that Harry is not a victim of ignorance about the inconsistencies, the dossier documents. He is a victim of knowledge. Trapped within a mutual understanding that was forged between two people long before the world knew the name Meghan Markle, and that has calcified over the years of their public life together into something with the quality of a formal arrangement, a shared commitment to a version of the story from which neither party can deviate without triggering consequences they have both decided are too severe to risk. The mechanism that makes Harry's silence a legal obligation rather than merely a personal choice is what the dossier calls the sovereign sponsorship mandate. Before the late Queen Elizabeth II granted her formal consent for the marriage, a consent that was required under the Royal Marriages Act, and that was given on the basis of representations made to her by both parties and by the palace officials, responsible for verifying them. Harry was required to sign a document that served as a legal guarantee of his future spouse's background, identity, and the accuracy of the information she had provided to Crown institutions in the process of the marriage preparations. Under the terms of that document, Harry assumed full indemnity liability for the accuracy of those representations. He is, in the language of the mandate, the guarantor of the record. The consequences of that guarantee, if the record is shown to be inconsistent with other official documents, are not abstract. They are specific, documented, and in the reading of the legal analysts who have reviewed the mandate in the context of the dossier's findings, severe. The immediate and permanent loss of his remaining inheritance interests, the total withdrawal of his official security protection from British government resources, the potential stripping of his remaining titles on grounds of fraudulent entry into the royal record. Harry is, in the formulation that has begun to circulate among those familiar with the dossier's contents, in a sovereign trap. If he acknowledges what the documents describe, he activates the consequences of the mandate he signed. If he maintains his silence, he continues to sustain a narrative that William is now actively and systematically dismantling through the mechanisms of the invisible hand. There is no comfortable position available to him. There is only the choice between different kinds of exposure and the calculation about which kind is marginally less catastrophic. Sources monitoring the situation in Montecito describe the atmosphere as one of high alert isolation. Harry has been seen pacing the grounds of their estate in patterns that those familiar with his behavior read as the physical expression of acute anxiety. He is, in the characterization of one person with indirect knowledge of the household's internal dynamics, a man who has been waiting for a signal from London, some indication that the situation is being managed, that the invisible hand has overreached, that the palace's appetite for this particular confrontation has its limits. The phone, according to these sources, has not rung from London in months. And the dossier that arrived on Tom Bower's desk this Saturday afternoon is not the kind of document that is sent by people whose appetite for confrontation has its limits. The financial dimension of the dossier's implications is the one that the business analysts monitoring the situation have been focusing on with the most intense practical interest. The legal and constitutional questions are significant and will unfold over the timescale of formal legal processes. The commercial consequences, if the material misrepresentation clauses in the Sussex's remaining contracts are triggered, will unfold considerably faster. The major streaming platforms and entertainment corporations that have entered into commercial arrangements with Harry and Meghan operate under contractual frameworks that include specific provisions addressing the accuracy of the biographical and reputational representations made by their commercial partners. These are not standard boilerplate provisions of the kind that are included in contracts as a theoretical safeguard and never actually invoked. They are provisions that the legal departments of major corporations include precisely because the commercial value of a partnership with a public figure is directly tied to the accuracy of the public identity that figure represents. If that identity contains material inaccuracies that were not disclosed at the time the contract was executed, the corporation has not simply been inconvenienced. It has potentially been induced into a commercial arrangement under false pretenses. The legal mechanism available to it in that circumstance is not just cancellation. It is clawback the recovery of the financial consideration already paid on the basis of representations that have been shown to be inconsistent with the documented record. The Project 1999 folder is the final sequestered section of the 42-page dossier, a section that, according to sources with knowledge of the document's full contents, is described even among those who have reviewed the preceding 41 pages with a quality of hesitation that suggests its contents represent an escalation. The label is not a date reference in the straightforward sense. It is a designation applied to a collection of documents that point to a specific period of the subject's history, a period that falls within the gap created by the biographical inconsistency the earlier sections of the dossier establish, and that contain records of matters that have never been acknowledged in any official biography or public statement. The nature of those records, as described in the fragments of characterization that have reached the people monitoring this investigation from the edges of the circle with direct access, suggests that the age inconsistency is not the only story the dossier tells. It may be the frame for a larger picture whose contents have been the most carefully guarded element of the identity management the dossier describes. By the afternoon of March 14, 2026, the people inside the relevant legal, journalistic, and institutional circles who had been tracking the dossier's provenance and its likely consequences had mapped the situation into 3 distinct trajectories. Each carried its own probability. Each described a different version of how the confrontation between the documented record and the public narrative would resolve itself. And each revealed, in the specific logic of its dynamics, something about the nature of the trap that the invisible hand had constructed. The first trajectory, what the analysts were calling Scenario Alpha, was the scorched earth legal campaign. In this version of events, the Duchess of Sussex instructs her legal team to file defamation proceedings against Tom Bower and his publishers, challenging the dossier's findings in open court and seeking to discredit the methodology by which they were assembled. It is, on its surface, an aggressive posture, the kind of response that signals confidence and resources and a willingness to fight. But it contains a structural trap that any experienced litigation lawyer would identify immediately: discovery. In English defamation proceedings, a defendant has the right to request the disclosure of documents that are relevant to their defense. If the defense of the dossier's accuracy rests on the comparative analysis of documents from multiple institutional archives, those documents become discoverable. Every vault, every filing, every record that the invisible hand assembled for the 42 pages would become, in a legal proceeding, public evidence subject to the court's examination. The lawsuit that was designed to challenge the dossier would become the mechanism through which its contents were formally validated. It would be, in the language of one legal analyst who described the dynamic with undisguised admiration for its architecture, a 5-year war that exposed precisely the things it was designed to conceal. The second trajectory, Scenario Beta, was the institutional settlement. The traditional royal approach, deployed in previous crises with varying degrees of success, a private arrangement reached through back channels at the highest levels, under which the subject agrees to specific constraints on their public activities, and the institution agrees to apply its considerable influence over the management of information in ways that prevent the most damaging material from reaching general circulation. This approach had the advantage of avoiding the specific public exposures that Scenario Alpha would produce. It had the significant disadvantage of requiring the cooperation of the Prince of Wales. And William, according to every account of his current disposition toward the Sussex situation, is no longer playing the institutional settlement game. He is playing for accountability. The old way assumes that quiet is the goal. The new way assumes that clarity is the goal. Those two objectives are not compatible with the same strategy. The third trajectory, Scenario Gamma, the one that the analysts assessing probabilities were weighting most heavily, was what they were calling the purge. Not the dramatic, explosive revelation of a single decisive moment, but the systematic, methodical, legally executed process by which the commercial and institutional infrastructure of the Sussex brand is dismantled through the activation of the contractual and legal mechanisms that the dossier's findings put in reach. Material misrepresentation clauses triggered in commercial contracts. Clawback provisions activated by corporations whose legal departments have concluded that the financial consideration they paid was induced by representations whose accuracy has been called into question by documented evidence. Regulatory and compliance frameworks engaged by institutions whose own reputational exposure depends on the accuracy of the information provided to them by their brand partners. The purge does not require a single dramatic confrontation. It requires a sequence of individually defensible legal and administrative decisions, each of which is entirely appropriate given the documented findings of the dossier, that together produce an outcome in which the Sussex commercial operation loses the financial and institutional foundation on which it has been constructed. Step back from the specific contents of the dossier and look at what William has accomplished across the 48 hours of March 13th and 14th, and the strategic coherence of what has been executed becomes visible in a way that the individual events do not fully communicate on their own. The steel strike on March 13th addressed the immediate commercial front, the Besties' retreat, The Australian petition. The diplomatic memo that reclassified the Mountbatten Windsors as private citizens with no claim on state resources. It was a public action, visible and declarative, designed to communicate to every corporate partner and government official who had been operating on the assumption that the Sussex title retained official institutional weight, that this assumption had been formally withdrawn. It sent a message about the present state of affairs. The dossier facilitation on March 14th addresses something deeper and more permanent. It is not about the besties' retreat or any specific commercial venture. It is about the documented record on which the Sussex brand's entire claim to authority rests, the identity, the biography, the institutional legitimacy that transforms a former actress and her husband into figures whose commercial propositions carry a premium that ordinary celebrity cannot match. The steel strike attacked the superstructure. The dossier attacks the foundation. The steel strike told the world that the Sussex title would no longer be officially endorsed for commercial purposes. The dossier, if its findings are validated through the legal processes that the material misrepresentation clauses are designed to trigger, establishes that the commercial use of the title may have been built on a foundation whose structural integrity is itself in question. William has not raised his voice. He has not given interviews. He has not authorized statements that invite a public argument with his brother and sister-in-law that would generate sympathy for them and drag the institution into the spectacle that they have always been better at navigating than the palace has. He has moved through official channels, used legitimate institutional authorities, facilitated the work of investigators with the standing to publish documented findings, and allowed the architecture of the law to do what it is designed to do when the integrity of official records is called into question. The invisible hand is not invisible because it is operating outside the law. It is invisible because it is operating entirely within it, using mechanisms that exist and that the palace has the authority to invoke in ways that produce consequences that are legally irreproachable and institutionally devastating. The 42-page dossier is no longer a secret. It reached Tom Bower's desk at 2:30 on a Saturday afternoon, traveling by a route that was not the standard one, bearing a stamp that carries the weight of centuries. The invisible hand has completed its delivery. The authority staircase has been assembled. The documents from the professional archive and the federal insurance filings and the comparative analysis of records from two different institutional frameworks are in the hands of an investigative author whose career has been built on the specific skill of knowing what to do with precisely this kind of material. Harry is pacing in Montecito. The phone from London has not rung. The sovereign trap is exactly as tight as it was when the dossier was first compiled, and the week's events have made it tighter. The besties' retreat has imploded. The steel strike has withdrawn the institutional endorsement that made the commercial operation viable. The dossier has placed the foundational documents of the Sussex identity into the hands of an investigator with the standing and the resources to pursue their implications through the legal processes that would give them formal weight. Each of these moves is individually consequential. In combination, they describe something more significant than a series of palace actions. They describe a campaign coherently designed and patiently executed by a future king who decided at some point that the time for passive management of a situation had passed and that the time for its systematic resolution had arrived. The Project 1999 folder sits within the dossier's final pages. Its contents, as described in fragments by those with knowledge of what it contains, suggests that the biographical inconsistency at the center of the authority staircase is not the end of the story, but the threshold of a larger one. The records it points to from a specific period of the subject's history that falls within the gap the dossier's earlier sections identify, records that have never been acknowledged in any official biography or public statement, are the material that those who have reviewed them describe as the most significant element of the 42 pages. Not because they are the most legally actionable, but because they are the most humanly consequential. They describe not an inconsistency in a document, but an erasure in a life. Whether the Project 1999 folder becomes public, how it becomes public, and what it means for the people whose lives it describes when it does, These are questions that the events of March 14th, 2026 have made answerable in ways they were not answerable before. The truth that has been maintained in archival systems and federal insurance databases and sealed university records and professional platform backends for years is no longer safely contained. The vault door has been left unlocked by a man who knows exactly what he is doing and has decided that the integrity of the record is worth more than the comfort of the silence that protects it. The invisible hand has delivered, and whatever comes next will be shaped in ways that nobody on any side of this story is currently able to fully anticipate. By the 42 pages that arrived on a mahogany desk in Kensington Palace on a Saturday afternoon in March, the truth is breathing, and it is getting louder.